DUI, DWI. Is there a difference? Hi, I'm Jeff Hampton with the Hampton Law Firm. Today I want to talk to you about DWI and DUI. Is there a difference? And by the way, I get these calls all the time. I'll have people call me all the time and say, hey man, I was arrested for a DUI. And I'll say, are you sure? Do you know if there is do you know that there is a difference between a DUI and a DWI? And listen, if you wait around to the end of this video, I'm also going to give you your ultimate guide to DWI defense in Texas. And I'll give that to you at the end of this video. All right, so let's talk about this. DWI or DUI, is there a difference? Well, let me just tell you right now. First of all, in Texas, because I want to talk about Texas law for a second, the main difference between a DWI and a DUI is that a DUI is picking up a DWI when you are underage, okay, essentially. Now, I'm oversimplifying it here, but if you're over 21 years of age, you're going to end up being charged with a DWI, driving while intoxicated, instead of a driving under the influence. Now, there's different requirements under different jurisdictions under the law. It's important to understand that every state has a different title for their definition of driving while intoxicated. So in some states, people do call it DUI and they have a different standard and a different law. But in Texas, the biggest difference is if you're DWI, you're at an age where you can drink, and we're going to talk about that standard in a minute. But if you're underage, you're under 21 and you pick up a DUI, that's when the DUI comes in, and it's a different level of offense, okay? Now, some states will call things totally different, and I say that to remind you of this. If you're watching this from New York, or you're watching this from California, or you're watching this from a different state, make sure you consult your law for your specific state to make sure that the terminology is the same, or if it is different, you'll know what the difference is between these two crimes, okay? Now, let's talk about DUI. So if you are under the age of 21 and you have here's the key, any detectable amount of alcohol in your system, you could be convicted potentially, or at least charged, of driving under the influence. Now, here's the big benefit to a DUI. A DUI originates in a municipal court, not a county court. So I'm not saying there's still not consequences because you're still arrested. You're arrested for a DUI, but the difference is it's not in a county court, which means in that situation, it's on the same level as a traffic ticket. So the actual punishment is no more than a Class C misdemeanor punishable by up to a fine of $500. It is usually also specific for an alcohol charge only. You're talking about here, driving under the influence, they're usually looking specifically at alcohol, okay? And here's the good news. If you're picking up a DUI, you were kind of fortunate. It's easier to resolve, in our experience, a DUI in a manner that allows you to get that case resolved and off of your criminal record in the future than sometimes a DWI can be. You're dealing with different prosecutors, different judges, different standards, okay? Now, that's DUI. Let's talk about DWI, driving while intoxicated. Here's what it says. If you're 21 years of age or older, if you operate a motor vehicle in a public place while intoxicated, you can be charged with DWI. Now here's the difference. Remember I said in DUI, it's any detectable amount of alcohol. Here with DWI, we're talking about while intoxicated. Well, what does intoxication mean? Intoxicated is broken down specifically. Number one, if you had alcohol or drugs, remember it can be a drug, a dangerous drug, prescription medication, illegal drugs, whatever it is. If you have lost the normal use of your mental faculties because of drugs or alcohol, or the loss of the normal use of your physical faculties. So whether it's mental or physical faculties as a result of the introduction of alcohol, those are two different ways that you can prove intoxication. And then the most common one we all know is being a blood alcohol level of 0.08 or higher at the time of driving your vehicle. Now let's talk about the difference here. DUI is a Class C misdemeanor, punishable by only a fine, right? Well, what about DWI? DWI is a Class B, if it's a first-time offender, Class B misdemeanor, punishable by up to 180 days in jail and up to a $2,000 fine. If you pick up a second DWI, it's a Class A misdemeanor, punishable by up to 1 year in the county jail and up to a $4,000 fine. Now, I do want to backtrack. If you have a first-time DWI and you're over 0.15 blood alcohol level, the state actually elevates that to a Class A misdemeanor as well. Same range of punishment, up to a year in county jail and up to a $4,000 fine. Finally, if it's your third DWI, you're in a whole other realm. You're talking about a felony DWI, and I encourage you to go back, watch some of my video series that we talk about felony DWI and DWI seconds, and we'll get into more detail on that. Now, what are the other consequences? Are there different consequences for a DUI versus a DWI? Yes, there are. One of those is the driver's license suspension. Under both situations, you have 15 days from the date of your arrest to request a license hearing. If you do not request a license hearing, your license will automatically be suspended 40 days after the date of your arrest. But here's the difference. If you have a driver's license suspension because of a DUI, a driving under the influence, you're looking at a maximum 60-day driver's license suspension, whereas you could be talking about 90 days or more, 90 to 180-day driver's license suspension if you're looking at a DWI, okay, a driving while intoxicated. Finally, what are some of the possible defenses? Under a DUI, a driving under the influence, well, here's one. If you're not driving, what if you're just sitting in your car, but you're not driving and the car's turned off, you're asleep in your car? We've had people sleeping it off. The cop walks up, tries to charge them with a DUI. If you're not driving, that's the wrong charge. It might be a different charge, might be public intoxication or minor in consumption or something along those lines, but that would not be the correct charge. What about if they illegally pull you over? What if there is an illegal traffic stop? If the police officer pulls you over and they did not have a reasonable suspicion to do so based upon articulable facts in a police report showing a traffic stop, your entire DUI might be able to be thrown out. Also, what if you had possession of alcohol but no alcohol in your system? And these are kind of rolled into the same defense. It goes without saying, if there's no alcohol in your system, you can't be found guilty of this. But sometimes officers will kind of jump the gun, arrest somebody for DUI because they had alcohol in their possession, or maybe they had an open container. They decided to go ahead and arrest them because of the open container. Open container is a different offense, okay? So those are some examples of defenses for DUI. Now, what are some defenses for DWI? Well, same ones. We can talk about if you weren't operating a motor vehicle, if you weren't driving, right, then that's a good one. That's a pretty good defense. But then also, what if there was no breath or blood test? And that still happens. You'll have jurisdictions like Colleyville and other areas, and I'm sure all over the country as well. Not all places still do mandatory breath or blood, more specifically blood draws. If that's the case, you're only now dealing with the opinion of an officer. And those officers can be wrong. And they are looking for any reason to arrest you. So if those field sobriety tests weren't done properly, if the investigation was done poorly, that's a good defense if they did not have a breath or blood test. Finally, what if the breath test or the blood test was done improperly? What if it was flawed? What if the breath test machine wasn't maintained? What if the blood draw was done improperly? What if the lab did not test it properly? These are all examples. And then here's another one. What if all this happened, but you weren't in a public place? Notice in the example here, you must be in a public place for a DWI in order to be found guilty. If you weren't in a public place, your case could be thrown out. And then, listen, there's many other things that we could go through here and talk about. The main goal of today was to talk about there is a difference between a DWI and a DUI. It's important to know the difference, and it's even more important to make sure you're working with a good DWI attorney that knows the laws in your state and in your jurisdiction. So if you or a loved one are facing a DWI or a DUI in the courts of North Texas, don't hesitate to contact the Hampton Law Firm at this number you see above. We'll give you a free case analysis or consultation. And I promised you a free ebook, The Ultimate Guide to DWI Defense in Texas. Click through down to the bottom into the YouTube description below, and I'll be happy to send you over that free ebook. Thanks for joining us here today. I'll see you on our next video.